So one of the things that we look at is assent. Did you have the capacity to assent? Did you make a deal? Did all of us were in the deal? One of the big problems we have with online structure is that the businesses like Apple really don't know if they've got a 12-year-old or a 21-year-old on that order form. And so this can be, especially if the parents are using the same app and have saved a credit card where somebody can sign in and just click and say, yeah, I want this. And the credit card's already saved. They just click a couple more times and they've bought something. And so there's been a dispute about this. I take the position that if it is a minor, that it should be a voidable contract. However, I would also argue that it is the parent's responsibility to supervise minors, and that I'm not a fan of letting kids loose on the internet without direct adult supervision. And I also feel that there are some changes that can be made and some steps where parents can keep a closer eye on their kids, and including letting them to work on their computers when they're not connected to the internet, and restrict their time to the internet connections when you are able to more directly supervise them. I know it's not always possible, especially as you get in 15, 16-year-olds and older. Obviously, they're going to have a lot more ability to do those things. So a law provides a remedy when a party misrepresents an important aspect of the contract. So we're going to take a look at some of the things. So again, you've got fraud, and we already talked about that. Fraud or unconscionable conduct are going to give people a way out. So here's several pieces of the deal. Undue influence, duress, and contracts of adhesion. Let's work backwards. We already talked about in this course contracts of adhesion, famous scene from The Godfather. Make him an offer he can't refuse. Contract of adhesion, easy, easy. Duress. Duress is very serious pressure on someone, not, hey, I am going to punch you in the arm if you don't agree to this deal. That's not going to get you there. But if I take out my 45 and I say, if you don't sign this contract, I'm going to make a really big hole in your head, that's real duress. So you can see where there's a judgment call between that and undue influence. Undue influence, unfortunately, in America, well, I guess fortunately and unfortunately, fortunately in America, we have a lot of people living to be very old. The downside to that is we have many of our elder family members, great aunts, grandmothers and grandfathers who are in assisted living facilities. Part of the reality of being in those assisted living facilities is you're not able to be there all the time. But you know who is? Those caretakers. And so if the particular person staying in the facility takes a liking to a particular worker and says, Sally's been wonderful to me, she's been much nicer to me and has had more contact with me than my own daughter, I think I'm going to leave her my whole estate. And when grandma passes away and they find her will, they find out she changed her will, leave everything to Sally. Well, I can guarantee you within about 48 hours, there'll be a lawsuit pending to alleging undue influence and trying to take away those that legacy being left to Sally. So it's, again, part of the modern reality of life. And it does happen. So, but notice that it is not the same level of pressure that duress includes. The next couple slides do, they're going to talk about mistake first. So one of the things that happens is, and let's use our auto dealer example. Many auto dealerships in their used car lot will take in a lease fleet. So maybe a bunch of cars that Comcast has used or a bunch of cars that Southwestern Bell has used, and so AT&T now. And so they've got a dozen Toyotas that are the same color, the same time frame, the same year. So you've got 30 identical 2017 Toyotas sitting on your lot. They're all painted white. your buyer comes in and she identifies a particular low mileage one that's very, very clean. She says, that is the car I want. I'll be back tomorrow. My credit union is going to finance it for me, and I'll be back with a check tomorrow for, $10,000. Well, she shows up the next day, and the dealership pulls a white Toyota out, but it's got much higher mileage, and it is not in as nice a condition as the one that the buyer picked out. There is a mutual mistake. The dealership thought she would take any car in the batch. The buyer specifically wanted to make sure that she got a particular one. Alfonso, go ahead.
Did she leave a deposit?
Very good point, because as you know from the previous chapter, needed to be consideration. Most of the time people do leave a deposit, and then oftentimes because they've driven themselves to the dealership, they say, you get the car ready for me. I'm going to line up financing. I'll be back tomorrow to pick up the car. It's not binding unless there's consideration. So good, very good question. Any other questions about that? But that's mutual mistake. Now, suppose that she assumes that they're going to give her the car that she thinks she's going to get, and she shows up and they say, well, there's 30 of these white Toyotas. We just take the next one in line, and that's the one you're going to get. So she may be unhappy with the deal because she made a mistake. She thought she was going to get a particular one or her pick of them, but the dealership says, no, that's not the deal we have here. You're going to take the first one in line because we don't want to move the other 10 cars that are in front of it to get to the one you think you want. They're all pretty similar. So it is a pretty interesting situation. So if it's a unilateral mistake, you're stuck with the deal. If it's a mutual mistake, it may be the court will grant relief and just say there was no deal. And that's what the next slide says. So we can keep moving. Now, one of the, this is a good slide to keep track of. This is slide 9 for chapter 16. And this is the types of misrepresentation. So if you have intentional misrepresentation, this doesn't usually happen with the big dealerships and even in their used car functions, but a lot of times you have these shady operators with these small used car lots out along the highways there, especially the ones that finance people that don't have any money. A lot of times the cars are not really in good condition. People have added special additives to the transmission or the motor to make the things run smoother temporarily, but they're not really set up for long-term use. And so if there's intentional fraud, you may be allowed to avoid the contract and in fact even get punitive damages. Now, if there's negligence on the part of the party, meaning that say that they take your car in and do a transmission job, you're out on the highway somewhere and the transmission fails because they didn't do the job right, then you can probably recover your contractual damages. On the other hand, if it's a completely innocent mistake, then they're quite possibly the victim will not have a path forward, unfortunately. So what are we looking for when we want to take action under fraud? That is intentional misrepresentation. This is a great lawyer word for you to know, and this is scienter. Scienter is to mean to do wrong, to have the intellectual intent to do wrong. You know what's right and you did wrong. Probably one of the most dramatic examples of that over the last 20 years, Bernie Madoff. Bernie Madoff knew from the get-go that he was a fraud. He ran one of the most incredibly large Ponzi schemes in history. And he told people that he was making all this money when in fact he was giving them a little bit of money from the new money that he was getting. He was not really generating the returns that he claimed and told people he was making. Very sad. As you know, some charities failed. Many people lost a great deal of money. One of the best cases of actionable intentional misrepresentation, the Bernie Madoff case. And so they concealed material facts in Bernie's case, Bernie Madoff's case, that he was not actually making the kind of money in returns that he claimed. The people that were customers of Bernie Madoff really were legitimate people. They were looking for good financial advice, and they had been recommended by other people in their circle of friends, and the people went to religious services with them, and they were reasonable in their reliance. And sadly, they suffered enormous damages, most of which will never be recovered because his fraud was in the billions of dollars. One of my favorites on misrepresentation is a dance studio. And again, speaking about some of our older citizens, one of the ways that some of them get separated from their money is by going to these commercial dance studios. And here's how this works. So, your great aunt goes into the local dance studio and she says, hey, you're very famous. I know that you're all over the world, and I'd like to dance like Ginger Rogers and Fred Astaire. So they tell her, you've got a lot of potential, and this is a great way to be fit, lose weight, meet people, maybe find another husband now that your husband's passed away. Let us help you become a great dancer. And they get her to sign a contract to, over the next 6 months, pay them $25,000. Yes, folks, I've seen incidents of this as high as $25,000 for dance lessons over just a 6-month period. Fairly shocking situation. So in any event, they tell your great aunt that she's going to be this great dancer and all this jazz, and they relieve her of a great deal of money. And then as she backs out at some point, they say, well, wait a minute, you've got a written contract. We're still performing. You may have decided, but that's, your decision and all that. So unfortunately, a lot of people, after they get into these deals, get down the road a little bit and realize that it's not a good deal for them. But then you've got to get out from under the contract. In many cases, they've taken money out of savings and paid the whole amount in advance, which is very sad because it's much harder to get back in those circumstances. So here's the slide that gives you a quick definition, a slide you may want to keep track of, slide 12 from chapter 16. Now, one of the reasons that you cannot agree to a contract is if you are incapacitated. And so the first one is if you're a minor. We've already spent time talking about this. I'm not going to revisit it, but someone under 18 is considered incapable of agreeing unless they are an emancipated minor. Someone who is mentally incompetent, and I think I mentioned this previously, is that one of the issues is many people are not that sharp, but have not been declared incompetent. And this is the real gray area that makes it very difficult for business people, because you are relying on the fact that this person is out wandering around, has a checkbook and credit cards and driving a car, that they are competent to enter a deal with you. And I'll tell you a sad, true story. Of course, I won't identify the client, but I do dispute resolution. I do mediations and arbitrations and collaborative practice. And I was asked to help a gentleman in a collaborative practice case. He was getting divorced after a very long marriage. His wife was an extremely successful business person. And he had been a college football player, a very successful one from a big NCAA Division I school. And as the cliche goes, he played too long And remember that up until relatively recently, a lot of football gear was not that protective, especially of the human skull. Many of you are familiar with the NFL settlement with the players over cumulative trauma disorder from being hit in the helmets not providing enough protection, too many head hits and stuff like that. So in any event, this guy did not play pro ball, but he played varsity, big-time varsity football. And as he got into his 60s, he began to lose a step significantly. When I met with him initially, I was so concerned that I had him go and be evaluated. I said, I will not represent you. I won't sign a representation agreement until you go and bring me some medical evidence that you're competent to not only enter into the agreement with me, but anticipating that we negotiate a mediated divorce with your wife, that it'll be a binding agreement. You're legally able to do it. So anyway, we went through several months of negotiations. We did reach a successful agreement. He got a pretty significant amount of money, and he got divorced. During that time, occasionally I would have some concerns, but again, assuaged by the medical professionals, I felt that, you know, we were doing the right thing for this fellow and for his family. So in any event, we reached an agreement. It all got done, signed, sealed, delivered. He's in an apartment. He's not working anymore. He's got some money. And he called me about a year later, and he says, help, help. They've taken my checkbook away. And I knew pretty much what had happened. In the most bizarre set of circumstances, his adult daughter and his ex-wife had to come in as his guardians because he was no longer competent. Those cumulative head traumas that he had suffered in his late teens and early 20s had caught up with him in his mid-60s. And even though he was now legally divorced, his adult daughter and his ex-wife were working to help him out. And indeed, they had taken his car keys and his checkbook and were going to be making sure that he was in a good facility using the money that he had received through the divorce settlement. But it was a very sad case. So again, sometimes you cannot really tell whether somebody's completely with the program or not. I've known a number of people who were bipolar, who on certain days we would have very good business meetings, and they were extremely sharp, seemed to have lots of good ideas, and then you'd find them disappear and living in their basement for 6 months, and you couldn't figure out what was going on with them. So a lot of difficulty dealing in this particular area. Intoxicated persons, most of the time we can tell if somebody is drunk, and obviously a drunk person cannot enter into a legally binding deal. Drug addicts, sometimes more difficult to tell if somebody is high on drugs. And it is potentially a situation, and we're not talking about illegal drugs, could be legal drugs that have had negative consequences on people. So something to keep in mind. We talked about minors before, and keep in mind that the minor can enforce the contract or avoid it. The adult is stuck with it. Keep in mind, one of the best examples of ratification is a minor enters into a contract. It's voidable at that point. After the minor is no longer a minor, they turn 18, they ratify the contract. They say, yes, I'm planning to comply with that contract. It is now not voidable. It is now a valid contract. Now, we've mentioned this, I think, earlier when we first introduced the topic, is we used an example of Justin Bieber before he turns 18 is out on a performing tour, and he books a room in an expensive hotel, runs up a huge room service bill. They may not be able to stick him with the whole bill. Say the bill's $20,000. But if they go to court, a judge might say, hey, you know what, $20,000, that's pretty rich. But the value of the overnight accommodations, the food that he had, realistically will order $5,000 be paid to the hotel. So they won't get the 20, but they'll at least get something. And again, we're looking at food, clothing, and lodging, medical services, and education. One of the things we want to mention to you is the contrast in third-party rights between common law and the Uniform Commercial Code. So if you buy something under common law that belonged to a minor, but if the minor elects to rescind, you're going to lose the deal. You're going to have to give it back. Now, under the Uniform Commercial Code, however, a person with voidable title has the power to transfer good title to good faith purchaser for value. So keep that term, good faith purchaser for value, in mind, because you're on the way to a holder in due course, which we're going to address later in the course. But keep in mind that this is a very powerful situation. What's interesting, the common law rule is still applicable to sales of real property by minors, which is pretty scary. Imagine if you think you've bought a property, a piece of real estate, and you move in and then you find out the minor changed their mind on the deal. So that's not a good situation.
I don't know, did we touch on the caveat emptor?
Well, we don't have that in that chapter, and I don't think they actually have caveat emptor in this in the whole section on contracts. And that's basically where we were debating the issue of unconscionability. So it's easy to say, let the buyer beware, which is the literal translation of that Latin, but you're expected to be at least half sharp. So unless there's fraud, duress, undue influence, and so forth, usually the deal is going to be enforced against you unless, absent some compelling legal reason to get out of the deal. But it's still good advice to people to be careful. And again, as business people, we're going to be treated more harshly. So we should make sure that we are very aware of the terms of our deal, number one. And number two, remember that we have legal counsel available if we need it.
Yes, I found it tied to the adhesion contracts because, as you know, in dealerships, we use adhesion contracts. It's basically the customer has to agree to what's to the standardized contract. And in most part, since they don't have a lot of bargaining power, the caveat emptor, takes effect. Like they know what they were signing for.
Okay. Yeah, it is a tough question, and we get asked that a lot. And the reality is that those standardized contracts may seem awfully unfair, but to call them contracts of adhesion, I think might be a little overstating the situation. There are contracts of adhesion out there, but I don't think the standard contract with somebody's buying a car from a dealership would meet that relatively high standard. Because remember, in The Godfather, the guy ended up with the dead horses. His beautiful prize-winning horse ended up with the horse's head on his bed the next morning. So I don't think we're at that level in the auto dealership. Is that a fair parallel?
Well, yes, it is. It's just that they also don't have a choice. Like they can't renegotiate the contract. It's standardized. That's what it is.
Yes.
The customer cannot go in the contract and say, okay, I want to strike through this sentence because I don't agree with this. So.
I agree with you. And in fact, as a business attorney, I'm frequently dealing with the businesses, and I tell them, do not modify the terms of these contracts. Very important, because you're not attorneys. Do not, if you delete a sentence in these standardized contracts, you may totally change the legal balance in the contract, which has been carefully written to be in favor of the business that's using the contract. So they don't want the individual salespeople or other representatives in the business renegotiating these important terms. So a good point.
So it doesn't make it an adhesion contract because the customer does have the choice, which is
To
not
walk
to sign.
away, right, is to walk away, and they're not under threat of a gun, or that would be duress.
Got it. Thank you.
Yeah.